Oyez, oyez, oyez. The Honorable, the Supreme Court of Texas. All persons having business before the Honorable, the Supreme Court of Texas, are admonished to draw near and give their attention, for the court is now sitting. God save the state of Texas, this honorable court.
Please be seated. Good morning. Welcome to the Texas Supreme Court. We'll hear arguments in two cases this morning. The first is 230676, Cactus Water Services against COG Operating from Reeves County and the 8th Court of Appeals. The second case is 230688, White Knight Development versus Simmons from Brazos County and the 10th Court of Appeals. In the first case, Justice Young is not sitting. Justice Boyd can't be with us this morning, but expects to participate in the case. The court has allotted 20 minutes for each side in each of these cases. We'll take a short break between the arguments, which can be viewed online and will be available on the court's website later today. We're ready for argument in 230676, Cactus Water Services versus COG Operating.
May it please the court, Ms. Livingston will present argument for the petitioner. Petitioner has reserved 5 minutes for rebuttal.
Mr. Chief Justice, may it please the court. The issue here is who owns the naturally occurring water that comes up when oil and gas is produced. I'd like to address 3 points and of course invite questions the court may have on other topics. 1, how the rule in Robinson maps onto COG's leases here. 2, COG's product stream theory of ownership. And 3, whether the substance at issue is groundwater.
Let me ask you, should we view this from the perspective of how this water is viewed today or how it was viewed back whenever the leases were originally entered? In terms of, you know, so many of these leases were entered at a time when people did not see this as a positive. It was seen as waste, a negative. And so how should we view that?
Yeah, and I think that there's a lot of cases, there are a lot of cases in the oil and gas context in particular because those leases are so long and have, you know, as long as there's production and paying quantities and they extend so long, that try to go back and unravel what do the words that are used in the leases mean, because it's pretty frequent that the parties had maybe no contemplation at the time that a lease was entered into about a particular substance.
Or that water would ever be valuable.
Correct. And of course, I mean, this court endeavors to fashion a durable rule that's not going to require a change in the rule when the economics might be different and a substance becomes valuable that was previously not valuable. And so I think that the court's jurisprudence rightly focuses on the wording of the instruments as the best expression of the party's intent. And I think that that's probably the most durable approach.
Well, we also need to know the background rule, right? And your position is that Robbins provides the background rule that mineral-bearing water is an incident of surface ownership absent specific conveying language to the contrary.
Yeah, Robinson, and it's citing Sun Oil for that, and actually that rule extends back pretty far. It goes back to the East case, and you know, it's based on an old English case, Acton v. Blundell, right? It's that base rule, it's a default rule, that if it's not mentioned, water belongs to the landowner. And so that is a background rule. It's definitely expressed in Robinson, and Robinson is certainly our lead case on that because it has the extensive discussion about a mineral that's in solution. In that case, it was a mineral in solution, salt in water. But that case also addresses if you were to have a mineral in suspension, which is like oil in water. And so, again, the court says it doesn't matter. We're not interested in a rule of ownership that would define water based on a mineral that's in, you know, suspension or solution. Interestingly, in Robinson, one of the briefs raised the question on rehearing, hey, the court's opinion doesn't address It addresses salt water coming out of a saltwater well, but it doesn't address salt water as an incident to oil and gas production. And the court wasn't persuaded to change its opinion, and didn't feel it needed to change its opinion. And let's just skip and talk to Robinson. We've really kind of gone back and forth in the briefs. It's our lead case. The Court of Appeals was persuaded by COG's argument that Robinson didn't apply because there, the water wasn't the target. That's what the opinion recognizes, on its face.
Well, and I think they distinguish between groundwater and produced water, water that is part of the stream of oil and gas that has to be then further dissected to be used as water, and so they call that produced water. And they point to the Natural Resources Code, which talks about it, and just wondering, and then I think their overarching argument is that we disfavor reservations by implication. So if it's groundwater, as you suggest, then it's not really a reservation because it belonged to the owner. What about whether it's something different than groundwater?
Right, so, great question. Groundwater is different than fresh water. It's different than drinking water. In fact, all naturally occurring water has a lot of contaminants in it. If you were to pull what we call fresh water, so-called fresh water, out of a freshwater aquifer, most of that has to be treated before it's drinkable. It's not like when you turn on the tap or you get some bottled water. That's not at all what it looks like. And so when we're trying to say what is this substance, when it exists down in the ground, the question is who owns it? It's down in the ground, and oil may be in the same pore space, it may be in another pore space, but it's oil and water don't mix, it's just down there. So the question is, who owns it when it's down there? Well, it's owned by the landowner. Unless
And who has the primary obligation for the disposal of it? I know in this case, there's a company that's interested in doing that for the landowner, but we have landowners all across Texas who I think the primary responsibility for taking care of the water that comes up as part of an oil and gas stream that responsibility belongs to the lessee.
And it does, and
It still does, is
and it still
your
does,
point.
right? And so right.
And you take net of that.
So,
In other words,
rephrase
you
that.
have the landowner gets the royalty whether or not there's costs associated with taking care of the pollutant waters.
That's right. And I mean, that's factored into the economics of every mineral lease transaction, right? It's an operating expense that the industry has already factored into how much it's willing to carve out in terms of a royalty. And so, I mean, you could have different lease royalty clauses, so, but setting that aside, the responsibility for the handling of that water, responsible handling of the water, Railroad Commission places that at least primarily on the operator or the generator, as the statutory terms or in the administrative code defines an operator who pulls it up out of the ground. It allows an operator to use Waterbridge, a midstream company, or somebody else, as long as they're not negligent and they have some reason to know that that's not don't have the right permits or things like that. And that's appropriate, because it's for the privilege of producing oil and gas, they have to deal with the responsible handling of the water, the duties there.
So why aren't basically both of you right in this case? That you own the water, because we've said that any any groundwater is owned by the surface owner absent an express conveyance to the contrary. But they're correct that this is waste for purposes of the Railroad Commission's regulatory scheme that puts a duty on the operator to properly dispose of it.
You couldn't have said it better, right? Or I couldn't have said it better. I think that that's right. It is both at the same time. It's not one or the other.
So how does that work? If you decide you want to exercise your ownership rights over this water that is also waste, are they still on the hook if you do it improperly? I assume you would have to bring in a licensee who has some sort of license from the Railroad Commission to dispose of this, because
Right,
you won't just let anybody handle this stuff,
Right,
and for
right.
good reason. But if your licensee does it negligently, are they on the hook?
Not according to the statutory provision.
Can you spin that out for me a little bit?
Right, chapter, at least in chapter 122, and they're also in the administrative code, there's a provision, and we've cited it in, I believe it's in our reply brief, that outlines when their liability would be triggered if someone other than the generator or the operator of the waste ends up handling it. And so it's a pretty high standard of negligent conduct. It's like they have to have reason to know it's not going to be handled properly before some liability attaches if somebody else is going to take the water. And so, but back to your first question, can't you both be right? And that's right. There are a lot of amicus briefs filed in this case. One that was filed in the last week, I think has a pretty good list of kind of bullet points of how this might work if you declare ownership of the water for Cactus water. How it would work, let's say, under the accommodation doctrine. And it's got kind of a bullet point list. It's the standard lithium brief, about pages 18 to 19. It just kind of gives a lot of examples. If this happened, then COG wouldn't have to accommodate them. If this were to happen, then they would have to do this. And so it gives you a feel for how in practice the rule might work out. And so I found it useful, and so I just commend that.
So the Court of Appeals, I think, was rightly concerned that Cactus couldn't just let the water sit there and cause COG to have its well shut down, and they talk about that in the
Right.
brief. So what if let's take not these parties, but some other hypothetical parties. If the person in Cactus's position just lets the water sit there, they say, we want to exercise our ownership rights over this. We have a licensee who can do it. And the licensee doesn't perform, and it just sits there.
Yeah.
Then it seems like the answer would be under the dominant estate theory that's not. The question there is whether it's reasonably necessary for extraction, and it seems like at that point the answer would be, well, it's reasonably necessary that they go ahead and dispose of this so they can keep extracting the water, and you've basically waived your ownership rights at that point.
At least to that quantity of water. I mean, I think that's right. And again, that standard lithium brief, I think, has examples just along those same lines that talk about, when it's reasonable or when it's not reasonable. I mean, we do have the strange position where we have two dominant estates. So we've got the severed water estate as to produced water versus the mineral estate. Because in Coyote Lake, this court recognized that a severed water estate is also dominant. That being said,
Well, it's dominant over the landowner, but is it dominant over the mineral estate? Because it's part of your argument is it's part of the surface estate.
right, dominant estate just means you have an easement, of course, right? So I can't go and take part of, if I'm an operator, I can't go take part of the surface estate and sell it for use off property. But the big thing that protects COG is if, or another operator, if the landowner or somebody like Cactus isn't acting reasonably in terms of don't have the right permits lined up, is not doing it timely, is not doing whatever, they get to lean into their dominant estate rights, and they can dispose of that water. They can use it on lease. And Cactus has nothing to say about that, or somebody in Cactus's position. So they always have that escape hatch to prevent these dire consequences like a shutdown or shut-in.
I'm concerned about liability
Yes.
for the operator. Having been in those shoes and having really the imposition of going to jail as somebody responsible for Shell Oil's disposal of this kind of thing, I guess it's just impregnated in my mind that at the end of the day, if some government agency wanted to swoop in and make you responsible, even though you had released it properly, and you can never escape. My sense was you can never escape potential liability for even wrongdoing by a third party. How do I get more comfortable with this whole idea of what you're proposing?
Yeah, and I think some amicus have suggested that, or supporting the other side, that, you know, the Railroad Commission may have to adjust their regulations, and that maybe that's appropriate, you know, to adjust those kinds of provisions about liability and who's primarily responsible. That may be appropriate. I see my light is on.
Any other questions?
Just one question, Council. In your view, does the oil and gas lessee here, COG, own any molecules of H2O at all?
No.
Okay.
Any other questions? Thank you, counsel. We'll hear from the respondent.
May it please the court, Ms. Stokes will present the argument for respondent.
May it please the court. This case is about oil and gas, not water. COG's leases granted the exclusive right to produce oil, gas, and other hydrocarbons and products produced therefrom. And for over 100 years, the parties to Texas oil and gas leases have consistently understood the ordinary and natural meaning of those granting words to mean the wet black stuff that comes out of the ground, all of the production from an oil and gas well. And as this court recognized in Bowden versus Phillips Petroleum, a lease's grant of the oil and gas necessarily grants those substances as they come out of the well in their natural raw form, and it includes all their constituent elements.
So if there's gold or lithium in the water, you own it?
Yes, that's correct, Your Honor, because as this court has said in Bowden and also in Lone Star Gas versus Stein, we are taking all the risk and all the cost of producing our oil and gas stream. We've been granted the oil and gas stream, and it includes whatever substance is in there. If you
But
take
your habendum clause only says oil, gas, and in some cases other hydrocarbons. So lithium and gold are not hydrocarbons.
But they are an inherent constituent element, assuming they're in there, of the oil and gas stream. And this court has said that that is what is granted. And that makes sense because you need...
Well, have we said that you have an entitlement to use the water for purposes of producing the mineral?
You've never...
I think that's exactly what we said in Robinson.
No, Your Honor, I respectfully, I disagree with you that Robinson did not involve produced water, did not involve any substance co-produced.
It involved mineral-bearing water produced from an oil and gas well, and we said that's an incident of surface ownership absent specific conveying language to the contrary.
Your Honor, respectfully, that was a failed oil well that never produced oil, and instead it was converted to a saltwater well from a water-bearing stratum that produced thousands of barrels of salt water. There was no argument, and there could be no argument by Robbins, that it was entitled to that water because it was produced along with oil and gas. Instead, they had this argument that they had been granted salt as a mineral and therefore in the water, and the court rejected that. And in fact, the briefing in that case distinguishes between the saltwater from the saltwater well and water produced with oil from other sources that Robbins was also using for water flooding, but which were not at issue in that case. And it certainly doesn't, Robinson was a 1973 case, vertical wells in a conventional reservoir in East Texas. certainly had nothing to say or anticipated Cactus's argument that you just heard today, that they own the microscopic, the H2O molecules that are bound by extreme pressure with oil and gas in these microscopic pockets in a tight shale formation. So I submit that the court has not reached the issue it's being asked today. And,
Well,
and
there's
to just,
also nothing in there, in any of our cases that I can find, that says you own any gold flakes that are suspended in the water. I think landowners would be quite surprised to find that out.
well, say, Your Honor, that, first I would say Moser versus U.S. Steel. This court said we've got to determine what was granted at the time, and that includes substances that the parties might not know the value of or even the existence of it. And if you
But the
take
character of them is not hydrocarbons.
but
which is
the-
what the
the
leases
plant-
say.
But this court has said, again in Moser, said we're not going to use a technical or scientific definition that would erase any distinction between the mineral and surface estates. And here, if you say any H2O molecule, wherever we find it, that belongs to Cactus, then you've just made the least nonsensical, because the oil and gas has H2O molecules in it after it's produced.
Sure it does, and we've said that you're entitled to use that for purposes of production.
Well,
And even if we hadn't, that's sort of the logical implication of the mineral estate being the dominant estate, right? You're entitled to use the surface estate for however you need to within reason to produce your.
well, I think the dominant estate assumes that this is water belonging to the surface estate. And to Justice Bland's question about groundwater, we know this isn't groundwater because the actual surface estate owners, Collier and Balmorea, specifically excluded, this is at Supplemental Clerk's Record 421 to 22, they specifically excluded groundwater and aquifer water and water-bearing formation water from the grant to Cactus, and only gave it the water that comes up out of a wellbore producing oil and gas. And even that produced water lease ironically recognizes the need to protect the surface estate owners' groundwater from this produced water that Cactus now claims and puts that duty on Cactus water.
So do you owe royalties on the produced water?
We would not owe them to Cactus water, Your Honor. We would, if they're owed to anyone, it would be to the mineral owner.
But why wouldn't they be, under your theory?
Because all the wet black stuff that comes out of all the production from an oil and gas well has been granted to the lessee under this court's precedent
Well,
in Bowdoin.
right, and so you should owe royalties
So it would
on
be
it.
the mineral owner that gave us that right, and so if there's a royalty owed, it would be to them. Now,
But is there a royalty owed under your theory?
this lease does not provide for a separate royalty on produced water, and that may be because the record is undisputed that we have made no money from this produced water. In fact, we spent over $20 million disposing of it safely in disposal wells. But that is not to say that under freedom of contract, a mineral lessor would be free to negotiate a separate royalty on substances that their value later became apparent. If you take the example of natural gas, many decades ago, people thought of that as a waste. They burned it off, flared it. Once it became, with technological advances, became valuable, the mineral lessor started negotiating for a separate royalty on gas. And so there's no reason that if produced water ever became recycled to the point that it was so valuable that an oil company was making a profit on it, which is not the case as you saw from the Produced Water Association's lease. It's really being used for refracking. They could negotiate such a royalty, but again, it would not be to Cactus, and Cactus doesn't ask for a royalty. Cactus wants the full value of the produced water, whatever that may be.
How does your theory square with the white oil cases, Amarillo Oil and others that said when you're granting oil, that doesn't include gas that comes up with the product stream?
So, Your Honor, I think Amarillo Oil actually supports our position. I think they get that case exactly backwards. There was a phase severance of the mineral estate, so it's still two mineral owners. There was an oil lessee and a gas lessee, and the fight was when the oil lessee was producing oil, there was some gas produced along with it, and they said, who does it belong to? So this court looked to the regulatory context and said, what's the definition of casing head gas? It's the gas or vapor that is produced along with oil from an oil well in an oil-bearing strata. And they said that belongs to the oil lessee. So consistent with Bowdoin, consistent with Lodestar Gas, and consistent with the regulatory context, they said that belongs to the oil lessee. And importantly, it was still all the mineral estate. There's never been a case that we found or that Cactus has cited that said any of the production from an oil and gas well is that some part of that belongs to the surface estate.
Well, the surface estate would still own any minerals that haven't been severed, like
That's right.
the
So
gold
it's-
or the lithium.
So say, yeah, it's the example.
And that's a mineral estate. It just happens to be owned by the surface owner.
So I would agree with you that we would not have the right to, as in the United States, lithium is, as the Standard Lithium Incorporated amicus said, we would, it's being mined from brine aquifers. It's not being mined from oil and gas production, and we would have no rights to go and take that lithium. What we're talking about in your hypothetical would be trace amounts of lithium in the produced water that currently is not the standard for producing lithium. But no, we would not claim the right to uranium pockets. That we are only talking about the natural and ordinary meaning of a grant of oil and gas, and that includes all the black stuff that comes up out of the well.
What about the salt formations? You know, we have a case on our docket about ownership of salt formation. Do you see the question in that case as completely independent from the one here? In other words, does there need to be consistency running between the two cases in terms of the operative rule about who owns that if there's not an express grant?
And are you talking about the formation itself, Your Honor? Yes, I think under this court's precedent, our position would be, and it'd be consistent with our position, that belongs to the surface estate unless expressly severed, because that is the reservoir. It's what the court has called the land mass. But nobody's making a claim to that. The court made a distinction between something embedded with minerals and something surrounding minerals. And so in your hypothetical, it would be the reservoir that we are not arguing for, the actual land mass underneath there.
How do you figure out whether a strata is an oil and gas strata or a lithium strata or something else? I mean, what happens if you've got 50% of one and 50% of another, and I'm drilling for lithium and brine, and a little bit of oil comes up with that? You would say you don't have any right to that?
So I think there are, and obviously in exploring and prospecting from oil, you are making scientifically based, but assumptions about what's below. But at least in our case, there's not, in these tight shale formations, this is not a situation with a conventional reservoir where you've got a big pocket of water and a big pocket of oil and gas or a big pocket of lithium.
Yeah, that's exactly why I'm asking the question, because you can have these strata where you could get oil and gas out of it, but you might be able to get other stuff out of it too. And so your theory seems to be that we're supposed to look at whether something's a byproduct or a target of the operation. And so I'm trying to figure out how that applies in unconventional strata.
Well, I think that that is Cactus's term for the target of it. I think it is.
What would you say the test is?
I would say it's. I think in these formations you're going to hit. If you have some trace amounts of something, but the primary purpose of the well is a brine well or an oil and gas well, that is determinative. But I think there are distinctions between these strata. Sometimes they don't hit the right strata, as in Robinson, they were trying to get oil and gas, but they had a water-bearing strata. But I think when the well is drilled, you know what you have.
We have all these nice things like gold and lithium and so forth that can come up, but there's also benzene, and there's also a whole host of other toxins that come up that how does that affect
You're exactly right, Your Honor, and I think the record is undisputed that this particular field, that there is hydrogen sulfide, which is very hazardous and regulated heavily by the Railroad Commission. There's chloride, there's all kinds of chemicals that would make it toxic to humans. And I think that's part of why nobody assumed, in the ordinary natural meaning of water, nobody thinks of this as water.
Do you believe you really ever escape liability?
I'm sorry?
Do you believe that you ever really escape all liability and potential?
I think that the Natural Resource Code and the Railroad Commission rules specifically say that even if we or delegate our duty to someone else, we're still on the hook if they do it negligently. So, and I think to the point of the Cactus Waters, well, this will just work out. You'll comply with your duty. They have actively said that they have the right to stop us from disposing of our produced water. That if they own it, they can prevent us from giving it to Waterbridge. While at the same time, they say that they have the right but no obligation to take the produced water, no obligation to recycle it, to dispose of it. And so what we're in a situation is that would significantly impede our ability to comply with our obligations under both the lease and the Railroad Commission rules and the statutes.
Well, this gets me back to the question I asked your friend on the other side about why aren't you both right? If they own the water, but you have an obligation to dispose of it, they can't stop you under the dominant estate theory. At least it seems like there's a good argument. They couldn't stop you under the dominant estate theory from disposing of it if they're not Johnny on the spot and get their contractor in there and they dispose of it. Not under a delegation from you, but as the owner. It seems like if they didn't do that, they would be waiving their rights, and you could go ahead and dispose of it and continue your production under the dominant estate theory.
Well, that's certainly contrary to, they have argued that paragraph.
Well, I understand it's contrary to their argument, but why isn't that correct?
Because it assumes, I mean, I think it assumes that you have two estates.
Well, and I know you don't agree with that, but if we assume that they're the owner, why does your sort of nightmare scenario necessarily follow? Why wouldn't you be able to dispose of it if they're not quick in exercising their ownership rights?
So if that were your holding, that they had some type of limited right, that they're less than they're claiming now, that they had to immediately take it or we get to dispose of it, they're still arguing that they have a right to a payment for our privilege of disposing of this toxic waste. And that is putting basically a tax on the production of oil and gas, which is already a risky and expensive proposition for no value or services provided.
I think under this hypothetical, they would have waived their ownership rights by not exercising them timely in a way that didn't frustrate the dominant estate's production.
Well, I think
so you wouldn't know if there wouldn't be a royalty owed or a payment owed.
I mean, that is not the claim that they're making, and I do think it would, as a practical matter, how would that work? I mean, we can only hold 24 hours worth of produced water in our tanks, so we have to check every day. Are you ready to take it now? Are you ready to take it now? I mean, and also, I heard my counsel say that, well, the regulatory scheme would have to change too, and so right now they're not regulated by the Railroad Commission. Right now, we would be in violation if we gave them unpermitted, unlicensed, the produced waste.
What about Natural Resources Code 122002? When fluid, oil and gas is produced and used by or transferred to a person who takes possession of that waste, the waste is considered to be the property of the person who takes possession of it for purposes of treating the waste for subsequent beneficial use. How does that play in, that statute play in with the property rights that we're trying to address here?
So I think what that statute reflects, Your Honor, is it recognizes the implicit assumption of this is that the producing lessee and operator owns that waste in the first place, because how would they be able to transfer ownership of it to a transferee like Waterbridge? And it's intended to promote recycling of waste, but the implicit assumption consistent with the common law, and is that is all part of the oil and gas stream that has been granted to the lessee.
Could you help me understand a bit more about the economics? So you have mentioned $20 million has been the historical cost. Would it be possible, if you were to come out victorious here, would it be possible for you to convert that into a revenue stream? Or is it the case, or maybe somewhere in between, or is it the case that just compliance with the regulatory requirements means that it would not be a revenue stream for you as it would for Cactus if Cactus were to prevail? In other words, will it continue to be a cost going forward for you? You spent $20 million historically.
Yes.
I wasn't sure whether that was a annual cost or.
That was for the period of the summary judgment, covered by the summary judgment record.
Okay.
Yes, we're continuing to incur costs into the future.
Okay, and so going forward, you expect that would continue?
Yes, as the Produced Water Association's amicus points out, right now, I mean, there's aspirational goals of being able to recycle this, perhaps for agricultural use, but right now, the primary use is, of produced water is either disposed at great expense, or it's treated at great expense, but then to be used as re-injection for fracking, so that you don't have to buy groundwater and use up freshwater resources. So we expect that cost to continue, and certainly what Cactus is saying is that we get to put a tax on top of that in exchange for no services, and it really could change the economics of the well, right? I mean, as this court has recognized, as a reasonably superior operator, we only have the obligation to drill wells that would produce in paying quantity, and if you're adding yet another cost onto it, it really can affect whether it's whether we're going to drill and produce consistent with the purpose of the lease and this constitutional policy of promoting oil and gas production without waste.
I have a question.
Okay.
Imagine in the future that a technology is developed that allows just the water to be extracted from whatever it is that's under the ground in a way that doesn't interfere with either, it doesn't diminish the minerals and it doesn't interfere with your ability to extract them. And this may be a fanciful technology, but just imagine that could be done. Could the surface owner employ that technology and extract the water without interfering with your rights?
I don't think so, Your Honor, because they'd have to drill into the same oil and gas strata that we're drilling into, and it would affect our ability to produce what's there, because, I mean, it's hard to imagine that technology because of the extreme pressure underground, these things are bound together in ways that wouldn't be.
My question's going to, is it your theory that you own that water in place in some sense? Or is it your theory that you own it because it's produced with the minerals?
Well,
Or both?
yeah, I mean, I think it's a little of both. We own, under, the rule of capture and oil and gas leases, we do own the exclusive right to produce the minerals, but under the rule of capture, we don't own each one until we produce it. So I think it's a little of both.
Any further questions?
Just one. Your friends from Standard Lithium say that maybe everything is moving too fast here, that it could disrupt oil and gas operations, but that it could also interrupt brine mining for lithium. What is your response to that amicus brief from Standard Lithium?
Your Honor, I think by the face of their brief, it's clear that what we are claiming here, the right to what we produce out of a oil and gas well, has nothing to do with their ability to mine lithium from brine aquifers. We are not drilling into brine aquifers. We have no right to do so, and nor would we claim that any lithium that they produce would belong to us. Thank you.
Thank you, Ms. Stokes. Ms. Livingston, I believe you have 5 minutes.
A few quick points. My friend refers to the Bowden case and the Lone Star versus Stein case and the all constituent elements language out of those cases. Water is not a constituent element of a hydrocarbon or of oil or gas. It's not cited, I don't think, in the briefs, but the Slavinka decision versus HSC pipeline, I'm probably not saying it right. I think Justice Bland may have authored that opinion for the court around 2020, 2022. It's got a good discussion to help anybody understand how, to decide whether something is a constituent element or not. The byproduct theory or the targeting theory, whoever came up with the word, I'm not claiming credit for it, I'm not denying it. I think that is a problematic test, right? I mean, what was the purpose of going into that formation? I don't think the court wants to create an intent test that creates a lot of fact questions. It also creates some mind drawing issues. If we're to posit a hypothetical where we already know there's a lot more water that comes up than oil, maybe there's even more water as the formation waters out. It increases the water cut, or the water ratio increases over time, or the value of water and oil changes, and so maybe they're an equipoise based on the volumes and the price. What's the intent?
What do you do with the language from the Natural Resources Code that was mentioned?
The Chapter 122 language. So the first thing I'd say is the Court of Appeals got this part right. We have leases that were signed in 2005, 2010, not our leases, the COG mineral leases, the Collier leases, there's 3 of them, 2005, 2010, 2014. Chapter 122 didn't get on the books until 2013. The Balmoral lease, I think it's also 2010. And in its original incarnation of 122.002, it didn't have language that applied to an operator. And so I don't know that Chapter 122 has a lot of application in this particular case. I think that there's maybe a looming fight over the constitutionality of Chapter 122 as a potential taking if it has the meaning that COG and other aligned parties would like to have. But I think that fight will be fought in a different case where that chapter actually applies.
Does the legislature have the power to adjust correlative rights in ways that it sees fit to benefit everybody?
It's going to have to go through that whole constitutional takings analysis and its police power and all of that. I mean, we have vested constitutional rights in the water that's underground. And so, again, that's a fight, I think, that's not queued up squarely by this case, and it's not squarely before the court at this time.
But we have to look ahead to it, because as the value of lithium versus water
Right.
versus oil versus benzene shifts.
Sure. If it has, as I read the statute, it reads like a bona fide purchaser for value statute. It doesn't actually say who owns the water to begin with. It says if someone takes the water for the purpose of reuse, recycling, et cetera, then that person owns the water. And so I think that the statute probably wasn't well written if the legislature intended to confer ownership of the water onto the entities that are mentioned in the statutory text.
I think
Well, I don't think the argument is that they meant to confer it. The argument is that everyone's assuming that that's already the case, and that's why the statute's written the way it's written. And that argument has some force when you pick up that statute and look at it.
Yeah, I think in terms of reasonable expectations and who assumed what, I mean, I think we have to factor in the Robinson decision and other decisions that have dated back for longer than Robinson about who owns water. And to be honest with you, it's been not a well-kept secret that there was been a question about who owns title to that water. That question has been around for a very long time, and every once in a while, people in the oil industry might say the quiet part out loud where they're not quite sure about the title to water.
Well, it seems like maybe the statute's trying to stay away from that question, because they say, you know, you can contract however you want, and as you pointed out, it doesn't say who owns the water when it's produced. It talks about who owns it when the person takes possession for purposes of treating the waste for subsequent beneficial use. And I guess that would be after the water has been separated from the gas, right? Because there's not, I forget the term that the statute uses, but fluid oil and gas waste, there wouldn't be any fluid oil and gas waste until you've separated it from the oil or gas, right? So,
That's right, right, it gets separated before metering, right? Because they're gonna separate the
Right.
water off from the, and then meter the oil and meter the gas. So that
and
is
so it
right.
would be after the separation occurs that somebody then would take possession of it for purposes of treating it for subsequent beneficial use.
Correct. Correct.
Any further questions? Thank you, Ms. Livingston. Thank you to all counsel. The case is submitted and the court will take a brief recess.